This program is brought to you by Emory University.
Well, when I came to Emory, it wasn't the Holocaust denial. I had written on Holocaust denial, but I never dreamt that I would be dragged into a personal battle with deniers. Emory was an attractive place to me. I liked the city of Atlanta. Emory had a great reputation. I knew people who taught here who were first-rate scholars. And I just thought this would be a good place for the next stage of my career. Little did I dream what would happen. I wrote a book on the history of Holocaust denial. In it, I briefly mentioned a fairly prominent or notorious Holocaust denier who, when the book was published in England, sued me for libel. And this precipitated a 6-year actually with the appeal, legal battle involving a 12-week trial in which I had to defend myself. I was on trial for libel. I was not suing him. He sued me. And the burden of proof, British libel law is the mirror image of American libel law. In here, if I say you libeled me, I have to prove you libeled me. In Britain, if I say you libeled me by what you wrote about me, you as the author have to prove the truth of what you said. So it greatly limited my ability to choose what to do. If I hadn't fought, he would have won by default. Had he won by default, he could have said my, David Irving, version of the Holocaust is genuine, and there was no plan to kill the Jews, there were no gas chambers, the survivors are liars, the Jews are making this up, etc. And I, David Irving, am therefore not a Holocaust denier. And even though many people would not have believed it or would have seen that it was illegal because I just chose not to fight, I couldn't afford to let that happen, so I decided to fight it. Initially, I was relying on my publisher, who was a co-defendant lawyer. Essentially, their lawyers are paid, as in any publisher, the lawyers are paid by the insurance company. And then people said to me, Deborah, that's not so wise. You really ought to have someone who is focused on your needs and your needs individually. So I managed through friends to reach a lawyer in the United Kingdom, Anthony Julius, who happened to be Princess Diana's lawyer, but a specialist in press and libel law, and he agreed to take the case. And initially he said, we'll do it pro bono, because they thought a couple of strong letters would make this thing go away. When it became clear that wasn't the case, he said the best defense is a good offense, and we decided to fight this in a very serious fashion. And at that point, the lawyer said to me, we can't do it pro bono. It's going to be practically our full time devoted to this. And we have to hire expert witnesses and other things. So I didn't know what I was going to do. And around that time, I got a call from the general counsel of Emory University, the then general counsel, a wonderful man named Joe Crooks, who called me to his office and said, tell me what this is all about. I told him, I briefed him, and I thought it was just informational. One of your professors is being sued, you want to know about it. And then a few weeks later he called me and he said, come back and see me. And I said, nothing's happened in the ensuing 3 or 4 weeks. And Joe said, come see me anyway. So I went to see him, and he said, the Board of Trustees met last night, and they decided to set up a fund for you of $30,000 to cover any out-of-pocket costs you might have. And then he said something very powerful. He said, we don't know your financial situation, and we're really not interested in that. What we ask of our faculty is 3 things. Be first-rate teachers, be first-rate scholars, and be morally engaged and ethically engaged. And we can think of no one who fits those 3 categories better than you, and we want to stand behind you. And then it came time for the trial. They called me and they said the trial will be in January 2000, and you should plan on being in the United Kingdom for 12 weeks. That's a semester. So I said to one of my colleagues, I said, I guess I'll take a sabbatical. And she said to me, Deborah, being on sabbatical and being on trial are counterintuitive. You know? So I said, okay, well, I guess I'll ask for a leave of absence, which in academic parlance was just a little easier to get. And I went to see the provost, the then provost, and I explained to her what it was, and of course she knew much of the background, and I said, well, I could do this as a sabbatical. She said, no, that's not appropriate. I said, I could get a leave of absence. She said, no, that's not necessary either. I said, well, I have to be in London. She said, you won't change anything. You will just be in London, and the courtroom will be as if it's your classroom, and we will learn from you from afar. And it was really quite powerful. I've told this to colleagues, many colleagues, hundreds of colleagues. I write about it in my book. And uniformly, every single one has said to me, whether they teach at a public university or private university, a well-known university, a lesser-known university, well-endowed, not so well-endowed, every single one has said to me, I cannot imagine that my university would have given me that kind of support. Had I won, they would have been very full of praise, and they would have, heaped me the accolades on me. But to give that kind of out-of-pocket and emotional support and substantial support and material support is something they all consider unique. And in the end, we won a resounding victory, a 350-page verdict in which the judge called this denier's version of history, and by extension, all deniers' versions of history, fanciful, made up, tragedy, a travesty of truth, and something that is done deliberately. It's not by chance. It really pulled the ground out from under hardcore Holocaust denial, the kind that says, there were no gas chambers, this was all made up. And it still exists, but it's seen as something with much more derision now than it was previously.
The preceding program is copyrighted by Emory University.